To understand family arrangements and intention to create legal relations, we need to begin with the landmark 1919 case of Balfour versus Balfour. In this case, Mr. Balfour and his wife went to England for a vacation. His wife became ill and needed medical attention. They made an agreement that Mrs. Balfour was to remain in England while her husband returned to Sri Lanka, and that Mr. Balfour would pay her £30 a month until he returned. This understanding was made while their relationship was stable. However, the relationship later deteriorated. The lower court found that there was sufficient consideration on the part of Mrs. Balfour and thus found the contract binding, which Mr. Balfour then appealed. Lord Atkin ruled that promises in spousal and in any family arrangements are not legally binding. Lord Atkin reasoned that, quote, if the courts were to allow all wives to come to court when agreements had been broken with their husbands, then the courts would be overrun with frivolous cases, unquote. The precedent set in Balfour is standard and applicable, such as in the 1969 case of Jones versus Padaviton. In Padaviton, a mother invites her daughter to quit her job, move to England in order to study for the bar, in exchange of a $200 monthly stipend offered by her mother. The mother then agrees to purchase a house for her daughter so she can rent out the other rooms and use the income as maintenance instead of the $200 stipend. The daughter gets married, doesn't finish her studies, and 4 years after its purchase, the mother wants to seek repossession of the home. The majority followed the precedent set in Balfour and reemphasized the presumption in the common law is that family arrangements are not legally binding.
Courts have rarely deviated from the standard of precedent set in Balfour. However, there are a few instances where family arrangements have been interpreted as being legally binding. In Merritt v. Merritt, Mr. Merritt left the family home to live with another woman. Mr. Merritt agreed to pay Mrs. Merritt £40 a month. At her request, he signed a document confirming that when she had repaid the balance on the mortgage, he would transfer the home in her name. Mrs. Merritt paid off the mortgage and successfully acquired a declaration that the house belonged to her. Mr. Merritt appealed. In this situation, the court ruled that when parties are in the process of separating or are separated, the presumption of there being no intention to create legal relations does not apply. Another exception are unilateral contracts. As we have seen, if the promisee begins performance, the offer of the contract cannot be revoked. Upon completion of performance, consideration will be given and the contract is legally binding. Family arrangements are not exceptions to these rules. In Hammer v. Sidway, an arrangement between an uncle and his nephew was found to be legally binding because the nephew offered sufficient consideration by giving up his right to drink and gamble for a certain period of time.
The precedent set in Balfour still applies and is often quoted in instances of family arrangements in modern Canadian jurisprudence. In the 2017 case Verard v. Verard from the Queen's Bench of Alberta, the litigation concerned a 5-acre parcel of land whereby Jim contended that he was promised the land by his father Dick, or by his mother Della, or by both, in exchange for work and caretaking done by Jim. Upon Della's death, Jim did not receive the lands. The court ruled that the agreement was not legally binding due to conflicting testimony and an overall lack of written evidence. Further, the court re-emphasized that without a contract, services rendered by a son or daughter for their parents cannot constitute performance or consideration. The most recent precedent in Canadian jurisprudence concerning intentions to create legal relations is the 2020 Supreme Court of Canada case known as Ethiopian Church of Canada versus Aga. In that case, the court re-emphasized that an intention to create legal relations must be assessed by an objective test. Specifically, the court stated that, quote, with respect to the requirement of intention to create legal relations, the test is whether parties have indicated to the outside world, in the form of the objective reasonable bystander, their attention to contract and the terms of such contract. Courts may consider the surrounding circumstances, including the nature of the relationship among the parties and the interests at stake, unquote.